So yes, in the last class we discussed about new duty situations. So a situation might arise in which judges have to hold that a duty exists. Okay. Now the jurisprudential question that also has been discussed is whether in doing so do judges create new duties or they merely hold that the duty existed in this new duty situation, which is a jurisprudential question, okay, that we discussed in the previous classes. So but then some say, okay, if you remember, some say that, well, judges merely recognize a duty which already existed, whereas there are others. Okay, for example, learned Judge Hand, and his economic approach to law of negligence. Okay, in his theory you might see that judges, while deciding whether a duty existed, are basically creating policies. Okay. So you have these opposing views, but we are going to discuss those in greater details later on. So with respect to all those cases, we had one last case which is to be discussed. It's the Caparo Industries versus PLC versus Dickman. So in this particular case, this idea of whether duty exists, okay, as we had discussed in Donald versus Stevenson, and how it was modified subsequently in Ends versus Martin London Borough Council, and some more elements were added to that. Okay, so in this particular case, okay, the House of Lords had approved of these principles, okay, in reference to the building case that we discussed, okay, but they also added some other elements. Okay, so 3 requirements are necessary to establish duty of care in the light of this particular case, that is Caparo Industries versus Dickman. Okay, so what are those? The first is the same that we discussed. Okay, it should be it is the foreseeability of the harm. So any reasonable person should be able to foresee that the harm is going to happen. Okay, and the second point is proximity. And proximity, you remember, it's not just physical proximity. Okay, it could be causal proximity. Okay, so proximity in relationship, okay, which implies that the parties are so related that it is just and reasonable that the duty should exist. Okay, and then, so you see within the point number 2 that we discussed, okay, so it's not merely proximity. Okay, judges add one more thing. Okay, and that is that it is just and reasonable that the duty should exist. So what do we mean by just and reasonable? So with respect to that project topic that we had that I had given you, and many of you had done wonderfully well, I mean, to what extent judges get to exercise their moral judgments. Okay, so when we talk about just and reasonable, it is not possible to legally lay down the exact situations when actions will be considered as just and reasonable. So in those situations, judges moral considerations do play a part in whether some act is just or reasonable or not. So yeah, so that is definitely there. So that's an element which was not there in previous cases. And last is the policy considerations. Okay, they talked about policy considerations here as well. So what they said is that policy considerations do not negate the existence of such duty. Now, if you look at what is being said here, that policy considerations do not negate the existence of such duty, what they are saying is that, well, the duty already existed. Okay, so duty existed. However, because of policy considerations, that duty is negated. Now, that is something which will not be accepted by certain jurists like Dworkin, if I understood this correctly. And why is that? Because Dworkin would say that judges have no business going into policy considerations. If at all anyone should be, concerned about that, that should be the elected representatives who are the legislators. They are the ones. It's not for the judges. Okay, judges are to decide based on existing rights and duties. Okay, but in this particular case, something was added, and that's that policy considerations do not negate existence of such duty. Now, this is the new element which was added in this particular case. Okay, now in this particular case, what had happened was that some auditors and accounts, okay, they were held not liable, to persons who had invested and then subsequently lost money in a company on the basis of the financial statements which were prepared by this accountants. Okay, so on these grounds, okay, it's not just and reasonable. Okay, it just does not make sense. Okay, to hold them responsible to the investors. Okay. So yeah, it was these two additional elements definitely did play a part in how the judges arrived at that conclusion. Now, with respect to this, I want to introduce you guys to one matter here. Okay, it's not necessary at this stage, but I think you guys should nonetheless know. We are going to discuss this if we have time in jurisprudence later on. Okay, so if you just click on the link that I have just shared, okay. At the bottom, you will see there's negligence highlighted there. Okay, so in there you see there's a case, okay, which was decided by Judge Hand. Okay, and he talks about when does this liability, when does this duty, okay, duty of care really exist. Okay, so if you can you access the link that I have just shared? Are you able to click on it? And okay, so go to the negligence portion at the bottom. You can read the rest later on. Okay, you will see there it's written the most common economic definition of negligence. Okay, now when we talk about economic definition of negligence, it seems to be that judges are dealing with policy. Okay, so that's the last thing that we discussed in the Caparo Industries case. Okay. So it says the most common economic definition of negligence can be seen in operation in Judge Learned Hand's famous opinion in U.S. versus Carroll Towing Company. Okay, the event that gave rise to the case were as follows: several barges owned by Conor's Marine Company were tied together off a busy Manhattan pier. Defendant's tugboat Carroll removed one of those lines connecting the barges to the pier. Okay. When the remaining lines broke, the barges were washed down river and sank. No one was aboard, and the barges, when they broke away, and the evidence indicated that the Conor's barge operator, okay, had they been on board, the barges could have been saved. The question for the court was whether Conor was liable for failing to have its bargee remain on board. So whether that duty existed or not is to be decided by Judge Learned Hand. Okay, so he is talking about Conor's liability for the lost barge. Okay, and he gives us a formula here. It's a very interesting formula. You can see how law and economics are connected in this particular example. He says the probability that she will break away. Okay, the probability that she will break away. The gravity of the resulting injury, what ultimately happens. Okay, the gravity of how serious is the resulting injury. If she does, okay, that's number 2. And third, the burden of adequate precautions. So these are the 3 things which are there. Okay, how likely is it that she will break away? What is the gravity of the injury? And the burden of adequate precautions. Okay, so you have BPL here, okay, as is indicated. So he gives you a formula here. Okay, now what do these 3 stand for? So P is the probability, okay, that it will get away. L is the gravity of the injury, and B is the burden. Okay, so liability depends upon whether B is less than L multiplied by P. Okay, so he says a defendant is negligent if B, that is the burden that you have, is smaller than the other 2 factors, that is probability and injury. Okay, so that's the formula which has been given here. Okay, so a defendant is negligent if and only if the burden here is smaller than the multiplication of L and P, that is probability and the gravity of the injury. This formulation of negligence rule has come to be known as Hand's formula. Judge Learned Hand went on to conclude that taking into account the surrounding circumstances, the risk, okay, PL outweighed the burden of prevention. Okay, so the risk, okay, outweighed, it was, more than the burden of prevention. Okay, so let's hold that the PL is equivalent to 5. Okay, whereas the burden of prevention was 4. Okay, because the burden of prevention was less. Okay, here the said defendant has been held liable. But imagine a scenario where the cost of preventing the incident is higher than what the risk. Okay, the risk. Okay, in such case, learned Judge Hand would say that it just does not make sense to hold the person negligent. Okay, so this is what has been very interestingly discussed. Okay, so we do not have any more time. I gave you some very simple explanation of how it has been decided here in this particular case. Okay, the rest kindly go through, because if we go through this whole thing, then it will take us forever. But I hope you understood. Okay, it's a very simple explanation which has been given, and we will study this later on in law and economics and jurisprudence. Okay, now what is being said here is this, that the judges, so when they do such calculation, okay, they are essentially deciding, taking into consideration certain policies. Okay, certain policies. Now this is something some other philosophers are not cool with. They'll be like, no, how can whether a duty or a right existed be decided subsequent to the event happening? Okay, the right already pre-existed, and you will find it in the legal system. So, and the judges are not to do such calculations. They have to decide based on the existing rights and duties. Okay, so yeah, I hope this much is clear. Are you guys with me so far? Are you guys with me?
Yes, sir.
Okay, so I'm sorry I have to move little, proceed a little fast, because I have to complete the syllabus as well, as much as possible. So the next element, okay, so there is an existence of duty, so that's done. So the next element is that duty has to be breached. Okay, if there is no breach of duty, then where is the question of liability due to negligence? Okay, so there has to be a breach of this duty. Okay, now what does this mean? Okay, it means failure to observe the expected standard of care. So there was a duty of care, so someone fails in observing the expected standard of care. Now what the hell is expected standard of care? Okay, it's something that a reasonable prudent person would do. Okay, a reasonable prudent person would do. Okay, now who's a reasonable and prudent person? Depends on the specific facts of the case. Okay, now if you're before a surgeon, okay, who's going to operate on you, okay, the degree of prudence here, okay, reasonableness, would be something that you would expect from a surgeon. Okay, not from ordinary people. Okay, but if it is something very ordinary, okay, then it would be reasonableness and prudence of ordinary person. Okay, now one more thing is that the degree of care also varies. Okay, the degree of care, the amount of care that one has to, the degree of care that one has to exercise. Okay, that will depend on how obvious the risk is. So it goes with the previous explanation as well. Okay, so a surgeon who's operating on someone has to show much higher degree of care, okay, than would be expected of ordinary person. So you would expect the surgeon to show surgeon's level of degree of care. Okay, and that depends on the kind of risk which is there. Okay, so it depends on how obvious the risk is. If the risk is higher, the duty of care which is expected is also higher. Okay, now that's something very important. Now let me tell you this. Okay, so if a person, okay, who has been bitten by a snake, okay, is treated by Gaon ka Ojha, okay, who claims that he's able to fix it, okay, and then as a consequence, okay, the person suffers. Okay, maybe it was how do you call it? The person suffers. Okay, loses some part of the body. Okay, whatever. Okay, what do you think? Would the Ojha be liable? The Ojha showed the best possible care. Okay, there in that case, you could not have complained of how much care he had shown. Do you think the Ojha would be liable?
No, sir.
Why
Sir,
would
should be liable. Sir, should be, because as a medical practitioner, if someone comes and claims to me that he or she is a medical practitioner of any kind, so he will be liable.
Okay, and Vikrant, why do you think the Ojha will not be liable?
I mean, the Ojha did everything that is to the best of his knowledge and to the best of his abilities.
Yeah,
But
here's the thing. Here's the thing.
To the best of his abilities, even if the said patient dies, the Ojha cannot be, obligated or to save every life.
Okay, so here's the funny thing. Okay, the Ojha is not competent to treat such a situation. Okay, the Ojha is not competent. So that's
considered as a medical practitioner.
Yes. So it has to be done. It has to be treated by a medical practitioner, as Aditya has rightly pointed out. Okay. So that's why. So some people who are not even authorized to deal with certain situations, why would you do that? When you do that, you are being negligent already. Okay. There is a breach of certain duty of care. So I mean it will make more sense in later cases when we discuss. Okay. So what I'm saying is the degree of care here would vary according to the obviousness of the risk. Okay. So the risk of the example that we just took, okay, is very high, okay, and a very high degree of care has to be exercised, and that can be exercised by someone who's authorized to do it. And Ojha is obviously not authorized to do it. When he or she does it, you're obviously failing in this duty here. So you should have not gotten into it, okay. So, and then apart from that, it also depends on how the situation has emerged. Okay, so for example, here's the thing. Okay, a doctor can sometimes exercise their best possible judgment. Okay, but the surgery might be such a difficult, sensitive surgery that it's possible for the surgeon. The surgeon has to take a call as to what procedure is to be, applied. But despite the best, judgment which has been exercised, something went wrong. Okay. So, and then later on it was found that had the surgeon done something else, the patient could have been saved. Okay. In such situation, this duty of care, standard of, this duty of care, okay, standard of care, which is expected of surgeon. Okay. Do you think the surgeon would be made liable in that situation? Because had the surgeon taken some other, alternative way of treating?
No, sir.
Okay.
No, sir.
So why is that?
Because, sir, he has given.
Yes, so it was such a perilous situation, okay, that in that moment you have to decide, and you cannot be expected to be a superhuman and then decide something perfectly. Okay, it just does not happen. There are those sudden emergencies that arise, sudden perilous situation in which you have to do something. Okay, you have to take a call. Okay, and in that moment, because you took the wrong call, okay, not deliberately, okay, then you wouldn't have breached in a particular duty. So that's the case. So it's very easy for you to understand. Okay. And then such breach of the duty, okay, has to be proximate cause of loss or injury, which we already discussed. Okay, it has to be proximate cause of loss or injury. It should not be too remote. Okay. So that's a very important, necessity here as well. So we'll discuss those in greater detail later on. So in a very important case by the name Manchester Corporation versus Marshland, I'll type it here. Sorry. Just a second. Let's see. So Manchester Corporation versus Marshland. Okay. So in this case, the Manchester Corporations, okay, service water pipe in a road burst, okay, and caused a pool of water to form on the road. The water lay unheeded for 3 days, okay. On the third day, a frost took place. It's a very cold place, okay. So on the third day, frost took place. because of which the water froze and ice was formed. Due to all of this, a motor car skidded. Okay, black ice forms, Due to all of this, a motor car skidded and knocked down, and a person was killed. The wife of the deceased filed a petition under Fatal Accidents Act 1846 against the owner of the motor car, okay, and the corporation, okay. So what was decided? The court exonerated the owner of the motor car, okay, but they found the corporation liable, okay, because they had not taken prompt steps to attend to the leak, okay. So the leak had been for a while, so they should have known that if the leak happens, the water will leak out, and then certain dangerous situations will arise, okay. They did not take the adequate precaution in this situation so as to prevent the road from being dangerous to the traffic, okay. So the company was held liable. Now why is that? Because that if the pipe bursts, it will accumulate on the road, and there's a very high likelihood that there'll be ice formation, and then there's a very high likelihood, because the cars move there, that they skid and end up accident. So yes, this is clearly a case of proximity of cause loss or injury. So are you guys with me so far?
Yes, sir.
Okay, yes, so sir. There has to be a breach of duty, okay. Without breach of duty, we cannot, say that, liability arises due to negligence, okay. So the breach of duty has to be there, okay, and if breach of duty happens, then liability arises, okay. So yes, in this particular case, you see that the example that we discussed, everything, fulfills, okay. Everything is fulfilled here, okay. A reasonable person, okay, the corporation here should have foreseen that, well, if this happens, then this is likely to happen, okay. And they should have shown a certain degree of care, okay, because of the obviousness of the risk, okay. And what had happened was proximate cause, okay, so of the loss and injury, and hence the corporation was held liable. I will share another case by the name Den versus Hamilton. Okay, I will share a link for the said case as well. Just a second. Okay, if you're able to see this, just click on it. It's another important case with respect to negligence. Okay, are you able to click on it? So you will see that the facts are discussed here. Not everything is necessary. A little bit of it is necessary. So in this particular case, the plaintiff, knowing that the defendant was drunk, okay, and that a road traffic accident was highly likely as a result because the driver was, drunk, chose to travel by the car despite being under no compulsion to do that, driven either by necessity or something else, okay. An accident occurred on the road, okay, which was caused by the driver's drunkenness, and the plaintiff was injured. She sued the driver's personal representatives, the defendant, for damages. In the action against him, the personal representatives raised the defense of volenti non fit injuria. Now, you remember the maxim, we discussed this, when we discussed defenses, okay. So you have put yourself in the way of injury, okay. So the issue here is, can the defense of volenti non fit injuria be used in order to preclude from remedy a person who has voluntarily accepted the risk which arises from the driver? So basically this passenger boarded without any compulsion, necessity, okay, knowing that the driver was under the influence of the alcohol, okay. So does the defense of volenti non fit injuria apply here, okay? So what was held, the decision was in favor of the plaintiff, okay. So in this case, okay, the defense of volenti non fit injuria does not apply to the tort of negligence till when, okay, that's to be decided, okay, so as to preclude from remedy a person who was knowingly and voluntarily accepted the risk which arises from the driver who is driving under the influence of alcohol, okay. So it has to be only in extreme cases that this defense of voluntary non-fit injury applies, and this is not one such extreme case, okay, and hence the plaintiff has the remedy under the law. So it was held the doctrine of voluntary non-fit injury applies to negligence only in cases where the plaintiff, okay, the plaintiff here by his words or conduct has impliedly agreed to absolve the defendant from liability. So had the plaintiff said that, well, I take complete responsibility, okay, I won't blame you because you are driving, under the influence of, alcohol, okay, hasn't done anything of that sort, okay. So you cannot say that, just because the plaintiff has boarded the bus which was being driven by someone who was under the influence of, alcohol would mean that the plaintiff would have no remedy. So it was held that the plaintiff had the remedy under the law. So
excuse me, sir.
Yes.
In this case, if driver are little intoxicated, then
sorry.
If driver are little intoxicated.
So you see, drivers were little intoxicated. See, in this particular, the driver was quite intoxicated. Even then, the defense was not allowed to the driver, to the representatives. Do you see it? So if the driver, in this particular case, if the driver was less intoxicated, okay, and nonetheless the accident happened, okay, then it will depend on how the accident has happened, okay. Do you see it? How the accident has happened, whether it is due to negligence.
Sir, it means magnitude of the risk is also important in the standard of care.
Yeah, obviously that's something that we already discussed, okay. But the thing is that it does not matter how much influence that you have. If you are under the influence of alcohol, there is already a established case of negligence on your part. Okay, so if you are a driver, okay, of a public, bus, okay, and then you are under the influence of alcohol, okay, in such case, you have already breached the duty of care, okay. Now, whether you are like completely, drunk or, drunk to a certain extent, how do we really, decide on that, okay. But then, obviously, the driver is doing something that is very, quite risky, isn't it? So you'd expect higher care from that driver, and obviously being drunk would say that the driver was not being careful enough, and hence, as you have rightly said just now, have breached the duty. So is that clear? Am I making sense?
So, but the plaintiff himself, as you said, put himself in the way of harm, and in a way, didn't he also
You're talking about contributory negligence, or are you talking? It's not a case of contributory negligence because.
No, so I was in general only just asking that. In a way, did he also not, if I can say that, breach the duty of care that he had towards himself?
There is no duty of care. It's a different philosophical question, okay? But you cannot take yourself to the court, okay? So there's no question of duty of care to yourself.
I'm not talking about taking himself to the court. Shouldn't it be a reason for not getting some compensation?
So that's essentially what you are talking about. The idea of contributory negligence. Okay, you might say that, well, you knew that this person is drunk. You nonetheless chose to board the bus, so you were being negligent as well. Okay, so hence you do not have the remedy. Okay, or if at all you are entitled to compensation, it will be likewise decreased because you also.
Yes.
But that's not how it works. Okay, someone who's driving, okay, just because the person is under the influence of alcohol, okay, the fact that I have boarded in itself does not say that, well, I have subjected myself to being driven around negligently. I do not consent to being consent to the bus being run negligently, okay, driven negligently. That's not what happens, okay, that's not the case. So that's why the court held that. See, the implication of this, okay, what would Okay, when I say implication, then I am I'm speaking like, that policy, approach, okay? But nonetheless, we know that judges at the end of the day decide based on certain policy considerations. So just think of the implications, okay? What will be the implications of holding that, well, you boarded the bus knowing that the driver was drunk, but you still chose to board, and hence you are not entitled to compensation. So just imagine this in our situation. You know that many drivers do, drive buses under the influence of alcohol. So what should we do? Should we deny these people who board the bus or car, okay, compensation? I mean, that's something that you as a judge will not do. Do you understand? If you were a judge and you had to decide, you will not do that, because you will know back then that, well, the person who has boarded the bus, knowing that the driver was, under the influence of alcohol, while boarding the bus, does not consent to being, driven negligently and then suffer as a consequence. So that's what was held in this particular case. Okay?
Okay, sir.
Okay?
Thank you.
So there are many more cases, okay? It just does not end. But then, if you want to read, just go take your book and then read. So we'll have to proceed to the next important topic now, okay? The next important topic is strict liability. Okay, this is something you guys have heard or studied even while preparing for your, CLAT exams. I think you guys have prepared about this, and it's known to, almost everyone. Everyone isn't interested in law. So strict liability. Okay, so strict liability. How is it related to negligence? Because when it comes to strict liability, one does not have to be negligent in the conventional sense that we understand, and nonetheless be liable for certain certain activities. Okay, so when does this strict liability arise? Okay, it arises, okay, when the activities, okay, that are done are just too dangerous. Okay, it's just too dangerous. So for example, if you have a house, okay, and you bring a vicious dog, okay, or a tiger, okay, as a pet, okay, so that's just not normal. Okay, now if you have brought such dangerous, animals on your land, it's your responsibility to ensure that the animal does not escape. Okay, so these are examples of activities which are just too dangerous. Okay. So, for example, if you plant a very dangerous, plant, okay, the berries that it produces, if it is consumed by human, they will, surely die, okay. You have to ensure that the branches of the tree does not escape, your land, or your land is not too easily accessible to, a child, okay. You have to ensure that it is fenced, okay. Otherwise, it might be consumed by someone, and then as a consequence, suffer some harm. Okay, so such activities would be very dangerous. Now, for example, if you have a land, okay, and you are building a huge reservoir of water, okay, this is not an ordinary use of land. This is something that is much more or beyond ordinary, okay, and involves a lot of risk. If you are storing some serious, okay, some very dangerous, gas, okay, barrels of gas or chemical, then you have to ensure that those do not escape, okay. So such examples of activities would be activities that are just too dangerous, okay, and they constitute a constant danger to person and property of others, okay. So till the time that those dangerous things are there, okay, activities or things are there, they pose constant danger to persons and property of others, okay. So in these situations, the standard will be different, okay. So what is the rule then with respect to such activities that are too dangerous? It is that those who resort to hazardous activities, okay, dangerous activities, such dangerous activities, must pay their way regardless of any fault, okay. So usually in the law of tort, your liability is based on your fault. If you remember, we started with this, okay. Tort is a fault-based liability, okay. You will be made liable for your fault. Okay, there has to be a breach of duty. Okay, but here is a case where it seems that it's a case of faultless liability. Now, depends on how you understand fault. Okay, so they say, so the idea is that if you resort to some really hazardous activity, some really dangerous activity, okay, then you must pay your way. Okay, you have to pay regardless of whether you are at fault or not. So, for example, you bought the tiger on your, premises. Okay, you have erected, perimeter fence. Okay, but the tiger nonetheless is able to jump across the fence and then, harms someone. In such case, maybe you have taken the precaution, that you thought would be necessary here. Okay, but then the tiger nonetheless escapes and harms someone. Okay, you were liable nonetheless, because the tiger, bringing tiger on your land is not a natural use of the land. Okay, it's not natural activity. Okay, it's a too dangerous and hazardous activity. So you have to pay your pay here, whether you are at fault that tiger escaped or not. Okay, so in such cases the risks are obviously inherent. Okay, so you have, even if you haven't been able to foresee this, the law will assume that, well, you must have foreseen this. What you are doing here is very dangerous. So whether you had foreseen it or not does not matter. You ought to have foreseen this. Okay, so that's the idea. Okay, so in such cases, in just the way we discussed in negligence, that in case of negligence you have to show reasonable care. Well, that defense of reasonable care does not apply in the case of strict liability. So even if you had shown reasonable care in ensuring that the tiger does not escape, but the tiger nonetheless escapes, well, the blame is yours. Okay, so for example, think of a tree, okay, that produces poisonous berries. You basically plant it on your land. You ensure that the leaves do not go over to the neighbor's house. Okay, but what happens is that the plant is of such a nature that it is able to proliferate through its roots. So the root go under the across into neighbor's land, and then a little tree comes up there and someone consumes and then dies. Okay, or suffers some injury. So in such case, that bringing the plant is very dangerous. Okay, you should have known. Okay, unless it's something that naturally occurs there, then obviously the case will be different. Okay, so in such case, if such an escape happens, then whether you took the reasonable care or not, okay, does not matter. The fact that you indulged in some something that is too dangerous and hazardous would in itself lead to liability, and that's what is known as the rule strict liability. So are you guys with me till now? Am I making sense?
Yes, sir.
Yeah?
Yes,
okay.
sir.
Yes, sir.
Okay. So a very important case of which you are probably already aware is Rylance versus Fletcher. Okay. So I'll share a link. It's probably have it with you already, but I'll share a link nonetheless. See, because I'm not here in the class, I would have given you the text on screen, but I have to use such links here. So, are you able to access it? I will go a little longer than the usual class I take. Okay, I just want to complete most of the topic on negligence as much as possible. So, are you guys able to see the case?
Yes, sir.
Okay. So this is a very famous case. Okay, this is a very famous case on the question of strict liability. Okay. So in strict liability, it is what other names do we know know it? Strict liability. What are the other names for this? It's also known as no fault case of no fault liability. Okay. Usually torts are based on fault based liability. Strict liability is also known as no fault liability. But then it depends on, as I said, what do you consider as fault? Okay, so something that happens despite reasonable care, okay, would not be considered as fault otherwise, but in such case it's fault nonetheless. Okay, so yes, in this particular case, what happens is that the defendants, okay, they employed independent contractors. Okay, they employed independent contractors, so they were not agents, okay, or servants. They were independent contractors. Okay, so the defendant will usually will not be liable for the acts of the independent contractors. Okay, so the defendant employed independent contractors to construct a reservoir on the land, and these were experts. Okay, these were experts in this field. The contractors, they found some disused mines. Okay, while they were digging. Okay, they did not seal those mines properly. Now what happened was that the reservoir which was constructed was filled with water. Okay, as a result, water flooded through those mine shafts into plaintiff's mines on the adjoining property. The plaintiff, first it was decided in favor of the plaintiff in Liverpool Assizes Court. Okay, then subsequently the Court of Exchequer Chamber held it in favor of the defendant, and then it was confirmed by the House of Lords. Now what was the case? Okay, what was the case here? Okay, you will see that there are 4 points which are highlighted when it comes to the case of strict liability. Okay, so it was decided by Blackburn J. Okay, Justice Blackburn, who delivered the judgment for the Court of Exchequer Chamber and the House of Lords that to succeed in this tort, the claimant must show 4 things. Okay, the claimant has to show 4 things. That the defendant brought something onto his land. Okay, yes, the defendant brought something onto his lands. Okay, the reservoir was created, and huge amount of water was brought there. Okay, and that's not a natural use. Okay, so the second point is that the defendant made a non-natural use of his land. Okay, now this is where judges will decide what is a natural use and what is a non-natural use. Now you know that bringing tiger on your land is definitely not natural. Okay, I mean whether it's too dangerous. Okay, so it's non-natural. Okay, in this particular case. Okay, then the third element is the thing was something likely to do mischief if it escaped. Okay, so in this particular case, had this huge amount of water, if it escaped, okay, then it will definitely, everyone would know that it will cause some mischief. Okay, and the thing did escape and cause damage. Okay, so if these 4 elements are there, then the defendant has to be held liable, and in this particular case the defendant was in fact held liable for all this, for fulfillment of all these conditions. Okay, now so yes, I hope these elements are so as you can see, it's discussed below in some more details. Okay, so we will discuss about this in greater detail and certain exceptions and we will take some more cases. Okay, so the idea is this, that owners or occupiers of real property, okay, we'll discuss what real property is in jurisprudence. Okay, so it's usually landed property. Okay, so and what is there on the landed property. So owners and occupiers of real property, okay, they have one responsibility. Okay, and it is known by the principle known as sic utere tuo ut alienum non laedas. Okay, sic utere tuo ut alienum non laedas. I'll just type it here so that you guys can see. Okay, so what does this mean? This means that everyone must so use his land as not to damage to another, do damage to another. Okay, so the law of property as it was traditionally understood, okay, within the law of property it was this, that if you own the property, you could do whatever you want. Okay, you could use it, you can modify it, you can destroy it, it's up to you because you are the absolute owner of the property. But with the changes in time, okay, as there were more, crazier ways of, using properties, came up, it was necessary that certain constraints, certain, restraints are imposed, okay. Why is that? Because while you use your property in the way you want, you may end up harming others. So that's the restriction which is imposed, that everyone must so use his land as not to do damage to another, okay. So while so for example, so we'll take up many examples. I need not give you an example now, okay. So as I say, the examples that we took, okay, so you have a landed property, you have a land, okay, you can do whatever you want there as is allowed by the law. But if you're going to do something which is very dangerous, okay, then, well, and then, that dangerous thing escapes, okay, and causes harm to other, then obviously you have to be held liable based on this principle itself, okay. So even when you have property, you can use it for ordinary natural use, okay. But if it is, okay, not natural use, okay, if it is not a case of natural use, then you will be held prima facie on the face of it, okay, prima facie answerable for any consequences that happen from such non-natural use, okay. But if it is a natural use, the owner will not be held liable unless it's a case of negligence, okay. So if it is a natural use, the owner will be held liable only if it is a case of negligence, okay. But if it is a non-natural use, okay, then you will be responsible on the face of it, prima facie. And that's the rule that we just looked at in the famous case of Rylance versus Fletcher, okay. So non-natural use, we took many examples. Bringing vicious dog, tigers, and why do I have tiger in my mind? Because all these web series, okay. So yeah, and then they escape and harm someone, so it's a non-natural use. Now whether it was because of your negligence or not is a different question. We do not go into it because it's a non-natural use, and someone is harmed, so you are prima facie answerable for that. So are you guys with me so far? Am I making sense?
Yes, sir.
Okay. So, however, this is the rule, okay? This is the rule of no-fault liability. This is the rule of strict liability. But there are certain exceptions, okay? There are certain situations when you can say that, well, I should be excused, okay? And what are those, excusable situations? What are those exceptions? We have discussed many of them earlier, so I need not go into details of that, okay? One is the act of God, okay, vis major, okay. So what is that? If you remember, it's, something that is beyond you, okay, something that is beyond you. It is direct, sudden, violent, okay, or, irresistible act of nature, okay, and you could not have foreseen the same, okay, you could not have avoided this, okay, exercising your ordinary human care or skill. So you do not have to be Superman, okay, or superhuman, okay, to know that, well, this could happen. If you were like, by ordinary person, okay, it's not anyone you find on the road, because most of them are not, exercising ordinary human care and skill. So yeah, anyone who exercising ordinary, reasonable, human care and skill could have foreseen it, okay, could not have foreseen it, then it is a case of vis major, okay, or act of God, okay. So act of God has been successfully used as a defense against this particular rule of strict liability. One case is by the name Nichols versus Marshland. I'll share the link with you. So, are you able to see this?
Yes, sir.
So, in this particular case, okay, it was found that that the defendant here, okay, what was the excuse that they would come up with? Well, vis major, okay. So this is case. There is one more case. Let me type the name of the case by the name Blitz versus Birmingham waterworks. Okay, in these two cases, okay, especially in Nichols versus Marshland, the defendant, in this particular case, the defendant had a series of artificial lakes, okay, on his land, okay, in the construction or maintenance of which there had been no negligence, okay. So they had constructed artificial lakes. They were not negligent, okay, in the maintenance. Now, what happened in that year? There was unusual fall of rain. So yeah, so if you were from here in Assam, you know that if it rains, the rain is like torrential. I mean, the entire state is flooded. Okay, so it rains very heavy here already. Okay, so it will depend. Okay, so in this case, in whichever place this had happened, okay, so there was some kind of unusual, fall of rain. Okay, it was so great that it could not have been reasonably anticipated. Okay, and as a consequence, some of the reservoirs, caved in. Okay, burst. Okay, and what happened was that as the water, went downstream, it carried away some country bridges. So it was held that the defendant was what? Was the defendant liable or not liable?
Sir, not liable.
Okay, why is it?
Act of God.
Okay, so because the rain was, not ordinary kind of rain as, people might have witnessed there, okay? It was so heavy that, no one could have known that it will rain that much. And as a consequence, the reservoir caved in, okay, gave away. And then the water went downstairs and then took some bridges with it. Okay, so it was held that, they're not liable. Okay, because of what? Act of God. So something which is not ordinary. It's out of the ordinary. So you see the quoted, marks there says that now the jury have distinctly found not only that there was no negligence in the construction and maintenance of reservoirs, it was done perfectly, but that the flood was so great that it could not reasonably have been anticipated, although if it had been anticipated, the effect might have been prevented. And this seems to us in substance a finding that the escape of water was owing to the act of God. However great the flood had been, if it had not been greater than floods that had happened before. So people there are not used to seeing such a kind of rain and might be expected to occur again. The defendant might not have made out that she was free from fault, but we think she ought not to be held liable because she did not prevent the effect of an extraordinary act of nature which she could not anticipate. So if what has happened is something which is of extraordinary nature, then you as a reasonable person would not be expected to reasonably foresee that. So that's what was held in that particular case, and accordingly the plaintiff was held not liable for this exception known as vis major. Okay, so we have another important case, okay, by the name Saraswati Parabhai versus Grid Corporation. Now in this particular case, what had happened was the Grid Corporation, they installed power line. So they had installed power line adjacent to some kind of dam or something. So what had happened was that one fine night there was extraordinary storm, lightning, rainfall, and as a consequence the pole fell into the adjacent pond and someone was electrocuted as a consequence. So what do you think the court would decide in this particular case? Anyone?
Act of God, sir.
Okay, anyone else?
Sir, I think the defendant was made liable.
Okay.
Yes, sir, because such things should be kept in mind.
Why is that?
So because Odisha is such a region where these things can happen.
Yes, so ordinary storm, lightning and this and that, okay, something that you expect, okay, it's nothing out of the ordinary, isn't it? And
Yes, sir.
they would not even be able to use the defense of, statutory authority, okay? Because, well, this is a clear case of negligence, okay? Your act has been done negligently. So, yes, in this particular case, it was not allowed because, the incident, the events here is nothing extraordinary. It is something that you expect as someone who's, so power lines are dangerous, isn't it? Okay. Aren't they? So yeah, so you should have taken much more care than you have taken. So that's how the the defendant was held liable and the defense was not allowed. Okay, in this
Sir, so in these situations also we have to take care of extraneous factors. Let's say, for example, let's take the Barge and the fires also. So we have to take, if we are drilling in a forest rich area, even if there is an let's say there's a heat wave or something, so we should keep all these things in mind in the strict liability also, because let's say I am digging for oil wells in an area which is not so which does not have so much heat waves, or which is not in a forest rich area. So I can I don't need to have such precautions. But let's say I am digging in an area which is forest rich, which has occurrence of heat waves. So all these extraneous factors also affect the imposition of strict liability.
Yes, so we have another kind of liability that we will go into, and that will address your concern. Okay, and this is something which was developed in India, as some of you have, also pointed out in your presentations. Okay, we'll go into that in a very short while, and that's a very important jurisprudential issue, especially in environmental, matters, as you have pointed out, the case of Barge recently. Okay, so we'll deal with that. Just bear with me for some time. Let's look at the exceptions. Then we will go into those cases in which even these exceptions are not allowed. Okay, these exceptions are not considered as exceptions, and that's known as the cases of absolute liability. So we'll come to that. Okay, so for now let's look at the third exception. Okay, known as wrongful action of the third party. Okay, so it was not due to negligence on the part of the defendant. Okay, it was not because of that, but it happened because of some act of third party. Okay, now what happens in those cases? So we have a case by the name Box versus Jub. Okay, I'll share this with you. Just hold on a second. So if you're able to go to this link, you will see that more or less similar kind of case. Okay, so the defendant had a reservoir on land. Okay, there was another reservoir situated at a higher level than the defendant's. Okay, so the defendant's reservoir was lower than another reservoir situated higher than the defendant's one. So what had happened was that the owner of this other higher reservoir, they suddenly emptied it, okay, through a drain, okay, that connected it to the defendant's reservoir. Okay, that caused the defendant's reservoir to overflow, and then it damaged the plaintiff, the claimant's land. Okay, so an action was brought. Okay, what was held? So it was held that the defendant was not liable for the damage as it was caused by the act of third party over which the defendant had no control. Okay, this is what was held in this particular case, because the defendant had not done anything. Okay, it is a non-natural use, obviously, but then defendant should be held liable nonetheless. But the exception here is that, well, the eventual occurrence that happened because of an act of a third party, and hence in this particular case the defendant was held not liable. But then here's a word of caution though. Okay, we should not be too easily excited to hold that, well, yeah, act of third party exonerates the defendant. No, not like that. Okay, you should nonetheless show reasonable care. Okay, so if you bring a tiger on your land, okay, you have fenced it, you kept it inside, but someone from outside opens the door and then the tiger escapes, okay? In such case, you cannot just say that, well, act of third party. You also have to show, reasonable care here. And that reasonable care would ensure that it's not possible for the third party to do something like that, okay? So you should not jump to, taking this as an exception. And it will depend on specific facts of the case, whether this would be available or not, okay? Another situation would be if the harm has happened because of plaintiff's own fault, okay? If it has happened because of plaintiff's own fault, then obviously, in such case, it can be taken up as an excuse, okay? So you put yourself, so for example, I have something dangerous, okay? I have a dangerous berry, okay, within my premises. I took all the precautions, I fenced my house properly, okay? Someone who managed to trespass into my land, okay, went there, okay, and accordingly ate the berry, okay? In such case, you see, it's plaintiff's own fault, okay? But you remember that, from the other cases that we discussed, okay, that you nonetheless need to show reasonable warning, okay, to people. So if you electrify fences, you need to warn people. That is also necessary. But suppose you have done everything that is, expected of you, okay, but nonetheless, plaintiff, suffers because of his or her own fault, then that could definitely be used as an excuse, as a defense. Another would be, if there is an artificial work, construction, okay, and that is for common benefit of both the plaintiff as well as the defendant, okay. In such cases as well, okay, the same could be that it is of common advantage, okay, common benefit of both the plaintiff as well as the defendant, okay, that could be taken up as a defense, okay. So let me share a case with you guys with respect to this. It is by the name Carstairs versus Taylor, okay. So in this particular case, what had happened was that the claimant stored rice in the ground floor of a warehouse, okay, which he leased from the defendant. Defendant also used the same storehouse, okay, the upper floor of the same storehouse, okay, for storage of cotton. So what had happened was that a rat gnawed through the gutter box draining water from the roof of the water house, okay. So there was a gutter box in which the rainwater would accumulate, okay. So the rat gnawed through the gutter box, okay, draining water from the roof of the warehouse. Now what had happened following this? A heavy rainfall happened and it caused the roof to leak, okay, and as a result, the claimant's rice was, damaged. So it was held that the defendant was not liable under the Rylance versus Fletcher strict liability case, okay, rule. The claimant had not brought the water onto his land to accumulate it, so that's one of the reasons. The heavy rain and actions of the rat were classed as an act of God, that's there. And apart from these two, it is also due to this that the said provision was made for the common benefit of both the plaintiff as well as the defendant. So if it is of such nature, okay, if such artificial work, okay, were for the common benefit of the both plaintiff as well as the defendant, then that could be used as an excuse, okay. One more excuse is that that any act which is for public purpose, okay, so in discharge of public duty as expressed under any particular authority of the statute. So this is an excuse that we discussed earlier, so we need not go into it. But as you know, even under this, okay, any act which is for public purpose, okay, even if it causes harm to someone, okay, because of the greater public good, it is justified. So it is quite often done by someone under statutory authority. But while the same act is done, okay, it cannot be negligently done, okay. So that restriction still applies. So yes, these are some of the defenses to strict liability, also known as kind of no fault, liability. Now the better case of, you can say the case of, no fault liability would be the case of absolute liability. Okay, this should aptly be called as no fault liability. Okay, now what is this? So this is a kind of you can say an extreme version of the strict liability. Whereas in strict liability, you had all those exceptions that we just discussed, okay? But in case of absolute liability, okay, there is no such exception, okay? Now, this was famously developed in the case of MC Mehta versus Union of India, AIR 1987, FC 965. So, just so that you know. So, as you know, there was, what had happened in this particular case? There was hazardous activity, okay? So some oleum gas was stored, okay? And storage of that, gas in itself is extremely hazardous, okay? And the same is a non-natural use, okay? So as we discussed earlier, it is definitely a case of non-natural use. And when it escaped, it caused harm to people, okay? So in such case, no justification is allowed, okay? And what the court did in this particular case was provide exemplary damages, okay? Damages which set an example so that in future no one does anything. So if you bring something which is dangerous, okay, on your land, okay, if you do something which is inherently very dangerous, the responsibility is up to you to ensure that it does not escape. Whether you are at fault or not, okay, you will be made liable. Now, it is again based on a particular jurisprudential or philosophical, or you can say political principle, okay. So what is that? So you know that in most such environmental disaster related cases, you see that big corporates, okay, they build big factories and then they involve in such hazardous activities, okay, they make profit out of it, okay, but then when accidents happen, it's the poor people who suffer, okay. Now if should such things happen, should the judiciary say that we have no help for you because the party took every care? But the fact that the party did something which is inherently danger, they're also making profit out of it, okay. So the court held that, well, you were responsible whether you were negligent and hence the accident happened, okay. It does not matter whether you were negligent or not, okay. You will be made to pay compensation, okay. Now another principle which was followed is that the bigger the enterprise, the more money that they make, okay, the greater compensation that they have to pay. You know that which particular position we are coming from, okay. So yes, that's what had happened in this particular case, okay. So in the case of your absolute liability, okay, none of these above defenses that we just discussed, okay, are available, okay. Similarly, it was the similar cases were also decided subsequently. Another case is J. Lakshmi Salt Works, okay, versus State of Gujarat. Aditya Jha, if I remember, had discussed this case, okay. In that case as well, the state was held liable, okay, for being negligent there, though, okay. And similarly, there are many other environmental law cases that you will come across, okay. Vellore Citizens Welfare Forum, Indian Council of Environmental Legal Action, etc. Many such cases on environmental law that you will come across in which the court has held or stood by the principle of absolute liability. You are responsible for the dangerous things that you do. So you do not have the excuse of saying that, well, it's not my fault. Well, the nature of the act itself is so dangerous and you're doing it in order to make money and you're profiting off of it, okay? And someone suffers who is not to be blamed for the suffering, then you must pay them for what you have done to them. So that's the extreme version of this strict liability known as absolute liability, more aptly known as no fault liability, okay. So that's it for today. That's a lot of discussion. So I hope I was able to answer that question that one of the students had raised. Who was it? Are you still there? One student just referred to
the environment one. That
yes,
was I,
yes,
sir.
yes, yes, yes.
Yes, sir. Yes,
So
sir.
you see how the court deals with such matters. Okay, so for example, while the drilling was being done there, okay, whether they were at fault or not would not really matter. The fact that something has been done which is inherently dangerous, okay, and it escapes, so it was clearly a case of escape. So the compensation has to be given, okay. But then in today's time you have most such industries, because their activities are inherently dangerous, okay, and there is always a likelihood of such accidents occurring, and you cannot say that you cannot do this, because sometimes such industries are also necessary for public good, okay. You need economy to grow, you need industrialization. So in such case we have to find out a solution. And what is that? So you have Public Liability Insurance Act, okay, and that ensures that people who suffer are immediately compensated, okay. But then it is not restricted to just that, okay, because insurance is there and hence no other compensation will be provided. That's not the case, okay. The court has laid down this jurisprudence and it is protected, okay. So the rule of absolute liability is there, and it is, if you ask me personally if it is okay or not, I think it's very important that rule of absolute liability is kept alive, okay, because there is always inequality between those who are powerful, are able to do whatever they want, able to use their money power to win court cases, okay. So it's better to ensure that those who are vulnerable are provided protection. So absolute liability is a good step in that direction, and this shows the peculiar nature of the community that we are part of, okay, an unequal society, economically, socially unequal. So we cannot just blindly follow the Western ideas of strict liability and the excuses that it provides, okay. So that's it, okay. So we will stop it there for today, and we'll proceed with the remaining topics under this module tomorrow.